Hello aspirants, welcome to Vyara IAS. So we were discussing Indian polity. As part of our discussion on Indian polity, we had already covered preamble and we started with fundamental rights. In fundamental rights, we had covered the meaning of right, the constitutional right and the inspiration behind having the fundamental rights. We had seen the significance of fundamental rights and also we had seen some of the characteristics of fundamental rights. Now we shall continue with the other characteristics of fundamental right, that is fundamental rights are called as suspendable in nature. That is fundamental rights can be suspended during emergency. That too emergency declared only during the national emergency. That is emergency is a separate topic in polity. We shall study about emergency later on in our video lectures. For now it is important to understand that fundamental rights can be suspended. That is, you can't go to the courts for the implementation of fundamental rights when it is suspended. That is, it can be suspended only during the national emergency. And the next point we must know is which all fundamental rights get suspended when the national emergency is declared. That is to be understood. So, when the national emergency is declared, according to Article 358, what it says is Article 19 gets automatically suspended. So, when the national emergency is declared on the grounds of war and external aggression. National emergency can be declared on three grounds. So, only when the national emergency is declared on the grounds of war and external aggression, Article 19 gets automatically suspended. So, the fundamental right that gets automatically suspended is Article 19 when the national emergency is declared on the grounds of war and external aggression. So, what about the case of other fundamental rights then? So, for the suspension of other fundamental rights, there is a need of separate presidential order. This is according to Article 359. So, according to Article 359, other fundamental rights also get suspended through a separate presidential order except Article 19, because Article 19 we have already seen it's automatically suspended, and Article 20 and 21. So, here what is to be understood is Article 20 and 21 are non-suspendable in nature. These are the permanent fundamental rights. That is, you can't suspend them. So, that is about the suspendable nature of fundamental rights. Next, we shall understand the classification of fundamental rights. So, at present we have 6 fundamental rights. Earlier there were 7 fundamental rights. That is, when India became republic, that is on 26 January 1950, we had 7 fundamental rights. Now we have 6 fundamental rights. So, the right to property, that is fundamental right mentioned under Article 19 1F and Article 31 was removed by 44th Constitutional Amendment Act in the year 1978. So, this fundamental right was removed. This is very important. This can be directly asked. The fundamental right that was removed is right to property, and it was removed through this act. This act also is important. So, at present we have only 6 fundamental rights. Now, let's see the list of fundamental rights. At first, it is right to equality. That is starting from Article 14 to 18. We had studied fundamental rights are seen in part 3 of our constitution, and it covers all the articles from 12 to 35. So, we shall see what is Article 12 and 13. So, for now it is fundamental rights starts from Article 14, that is right to equality from Article 14 to 18. Next we have is right to freedom from Article 19 to 22. Next is right against exploitation, that is under Article 23 and 24. Right to freedom of religion, it is from Article 25 to 28. The educational and cultural and educational rights are provided under Article 29 and 30. Right to constitutional remedies are given under Article 32. Here it is to be noted, that is Article 31 is not seen, that is it is removed. Right to property is removed. That is what we studied. Nextly, we must understand what is Article 12. Article 12, it defines state. State is not about the state that we see. In polity, the meaning of state is, that is according to Article 12, state it includes the union government, state government, the local bodies like panchayats and municipalities, and it also includes other authorities that are seen within the territory of India and also those that are under the control of union government. So this entire thing is the definition of state. And also take for example the public sector undertakings, that is those that are under the control of government or those that get the aid of government, those that are under the monopoly of government. Take for example the railways and also the PSUs and other public universities also come under the definition of state. Next, we must understand Article 13. Article 13, it defines laws, it defines law, and it also says that the laws that are inconsistent with fundamental rights are invalid. Who declares that the laws which are inconsistent with fundamental rights as invalid is? It is by judiciary, because judiciary can interpret the constitution. I had already said Article 13 defines laws. So, laws, it can also include the notifications or any orders that the government passes, and also it includes the customs also. Take for example, the Shabrimala judgment and the triple talaq judgment. Judiciary interpreted the constitution and gave judgment because this customs are also covered as laws as per Article 13. Keep watching Vyara IS for further Indian polity lectures. Thank you.